Hello everyone, my name is Donna Short. I'm a partner in the Intellectual Property Group at Addisons, and my co-presenter is Hazel McDwyer, a special counsel in the Intellectual Property Group. Today we're talking about commercialisation of IP, and we're going to cover a range of issues today. The first area is the phases of a commercialisation project, then commercial considerations, and then we're going to look at all the different types of intellectual property that you would need to cover off in a commercialisation agreement, such as patents, trademarks, copyright and designs. And then we'll look at cross-border issues. A lot of intellectual property arrangements these days, and particularly the larger ones, involve companies in different jurisdictions. So we're looking at cross-border issues. And lastly, we're going to give you some tips and tricks, because Hazel and I have worked in this area for a very long time, and so we're going to give you some of our insights into the area.
So when you're looking at the phases of commercialisation, there are broadly the four phases of commercialisation which reflect the product life cycle. So your phase one is your research and development section. And this is when you might have your R&D agreements in with contractors or third parties, or you may be doing this completely internally yourself. The next phase is the creation of a prototype or the prototypes. At this stage you might have your manufacturing agreements with third parties. Again, it's very important to have from the beginning, have your confidentiality agreements in place with all of these phases. Mm-hmm. And Donna, what would phase 3 be?
Okay, so phase 3 is when you've developed a prototype and it's now at the stage of manufacturing. So this stage you're generally doing the final refinements on the prototype, and then you're looking to appoint a distributor. Well, first we've got to appoint a manufacturer, and to manufacture the actual technology product. And also at this stage you look at branding issues, and so this is when trademarks become important. What are we going to call this product, and looking at the IP protection in regard to trademarks. Then you have phase 4, and phase 4 is distribution. So you're looking at appointing a distributor, or are you as the company going to distribute the product yourself? Also, is it going to just start off in Australia, or are you actually going to distribute internationally and maybe appoint distributors in different countries?
Okay, and then when we're looking at commercialisation, then I suppose one of the things we really need to think about is the type of IP right that we're commercialising. Mm-hmm. So we'll chat a bit today about trademarks and patents and copyright and designs, and just some of the different issues that arise with commercialisation of those rights. So for firstly looking at trademarks, so this would be a sign that you use to distinguish your goods or services from those of another trader. So your likes of Coca-Cola, for instance, mm-hmm. that we would all be quite familiar with. And that gives you, a registered trademark will give you the exclusive right to use that trademark and to authorise others to do so. So, as you mentioned, the trademark should be considered at a very early stage, because it takes 7.5 months to register a mm-hmm. trademark. Mm-hmm. So it needs to be thought of early, so that ideally you'd have your registration by the time you come to market. And then, do you want to mention the unregistered trademarks?
Sure. So you've got registered trademarks, but you can also use trademarks and not register them. If you just use an unregistered trademarks, then you build up common law rights. And if someone else starts using the same mark for very similar goods or services, then your causes of action are passing off or misleading, claiming misleading, deceptive conduct. So with a commercialisation arrangement, you're better off to register your trademarks, because you've got the protection of the Trademarks Act, and it's also much easier to pursue infringement proceedings. Whereas, claims for passing off and misleading, deceptive conduct, you've really got to show your reputation and goodwill in the trademarks. So yes, you can have unregistered trademarks, but there are certainly lots more benefits in having a registered trademark. Absolutely. The other thing I just wanted to talk about is the term of protection for a trademark. A trademark is registered for 10 years, and then it can be renewed in perpetuity. So it's in fact the IP right that has the longest protection, because it can be renewed for such a long time. The other thing about trademarks is that you can assign them or you can license them. They're personal property, so there's a lot you can do with them. They're an asset of the company. If you are going to assign then it must be in writing. And if there is an assignment, for instance, if I have a registered trademark and I'm assigning to you, then I need to make sure that my assignment's in writing. And then once you've done the assignment, that's a legal assignment, you then need to register it with the Trademarks Office so that it's recorded on the register. The next area we wanted to talk about was patents. And patents have patents are granted under the Patents Act in Australia, and they confer on the patentee the exclusive right to exploit the invention. In Australia, we have two types of patents. You can have a standard patent or an innovation patent. And recently, there has been discussion about basically no longer having innovation patents. They're still around at the moment, but it is something to keep an eye on. A standard patent, basically, in order to get a patent registered, it needs to be, or the invention needs to be patented. It has to be new, involve an inventive step, and be able to be used, made or used in an industry. So the thing is with a patent, it covers inventions and it has to be new and inventive. So it has to be something that's not existing technology. It has to be a new technology. The other thing about a patent is that once it's granted, you have a monopoly for 20 years, which is a long period of time. With pharmaceutical patents, you can actually get a longer period of time, up to 25 years. So Hazel, I've talked about a standard patent. Do you want to talk about an innovation patent?
Sure. So the innovation patent, as you mentioned, is very much an Australian phenomenon. It has a shorter period of protection, so it lasts for 8 years. The threshold of patentability for an innovation patent is lower than a standard patent, so you have to have an innovative step. So it covers a lot more incremental inventions, and it's also useful where you have a patent that you may not need it for 20 years, for instance. It's a lot cheaper and easier to get registered. So as a commercial and financial risk early on in your R&D process, an innovation patent can actually be quite helpful in that regard. Because once it's registered, assuming you've certified it, you'll have the same rights as you have for a standard patent. It's just for a shorter lifespan. So it's certainly worth looking into when you get to commercialisation. Of course, one of the issues is confidentiality, which we mentioned earlier, and I think for patentability it is very important.
Absolutely. So with confidentiality, and it really, we're going to talk about it in a number of areas in talking about commercialisation agreements, is with a patent, you have to keep it confidential until you've filed your patent application, because if it's out in the public domain, you actually lose your rights to obtain a patent. So if you're engaging in discussions quite early in the piece with another party, then it's important to have a non-disclosure agreement in place so that you keep your invention confidential. The other thing that I wanted to mention was a provisional patent application. And essentially what a provisional patent application does is it's like a placeholder. So what it enables you to do is you file, and a patent attorney files a provisional patent application, and it allows you 12 months. And if you're developing technology, it's quite a good thing to do, because you can file your provisional patent application, you've got a placeholder, and then it allows you 12 months to think about, okay, we can then, at the end of that, think about whether we want to have a PCT application that is go internationally or just limited to Australia. So it just gives you a bit of time. Hazel, do you want to talk about the rights of the patentee and also ownership issues?
Absolutely. So under the Patents Act, unlike some of the other IP legislation such as the Copyright Act, there's no automatic provision for the employer of an employee to automatically own the patent that the employee has invented. So it is important when you're looking at commercialisation to make sure that you have your relevant agreements in place with your employees or your contractors to make sure that if you've got someone who comes up with an invention, that they assign it to you early on, and that you can then be the patentee. So it is important to have that in place. Also for joint owners, that's also an important issue to look at in relation to patents, isn't it?
Yeah. So if you've got two parties that are going to jointly own a patent, then they hold it as in equal and undivided shares as tenants in common. So as joint owners, if you do go down that path, then ultimately you're really bound to your joint owner. So you can't assign it or you can't license it without the consent of your joint owner. Hazel and I tend to discourage clients from having joint ownership of IP because it just means that you're bound to that other party for a long period of time. I mean, if you've got joint ownership of a patent, that's 20 years. And it may be that, you want to go your separate ways at some point in time. So it just adds another level of complexity. Also with a patent, it is like a trademark, personal property, so it can be assigned a license. The next area we want to talk about is designs. And in order to have protection for a design in Australia, it has to be registered, and it's registered under the Designs Act. And people often sort of get confused between patents and designs. And I suppose the main thing to remember is that a patent is covering an invention, whereas a design registration covers design features, so ornamentation or visual features of could be an industrial product or other type of product. So it's really covering appearance. So in order to get design protection, the design has to be new and it has to be distinctive. So again, not something that's already out there in the public domain. And I suppose that's also another case of confidentiality. If you're developing a new design, then you really should be filing your design application before you start manufacturing, before it's out there and you start selling the product. If you have started selling the product, then it's too late. You can't register your design.
Absolutely.
So with design protection, it lasts for 5 years, and then you can extend it for a further 5 years. But that's it. You've got 10 years, and then once the 10 years is up, unlike a trademark which you can renew in perpetuity, it's only lasting for a period of 10 years. So Hazel, do you want to talk about certification and what that means for designs?
Absolutely. So one of the advantages of design registration is that it can actually happen quite quickly. But one of the things that doesn't happen automatically unless you apply for it is certification of your design. So you can get a registered design, but you can't actually enforce it until it's certified. So really, as a commercialised product, it would be better if you want to commercialise your design for it to be certified, because then it's a lot more valuable. So let's say it's the shape of a product, for instance, a cosmetic product, and you had a particular shape or an aerosol can that you want to commercialise that. It really was best for you to certify it beforehand. So that will stop third parties from, allow you to enforce it against third parties. Designs as well can be assigned and licensed the same as any other IP, and again, because they'll be recorded and registered, we need to have them in writing. Do you want to talk about copyright briefly?
And copyright, unlike the other heads of IP that we've just talked about, trademarks, patents and designs, you don't register copyright. Copyright subsists on creation of the work. Under the Copyright Act, there's a number of areas you can protect. You can protect literary works, musical works, artistic works and dramatic works. And you can also have subject matter other than works, such as sound recordings, films, sound broadcasts and published editions of works. The other area that people tend to forget about is that a computer program is actually a literary work protected under the Copyright Act. So object code and source code is actually protected. And a lot of commercialisation projects involve some form of software. So it's really important to have a think about that when you're doing your commercialisation agreements, that you do cover copyright works. In terms of ownership of copyright, copyright vests in the creator of the work. So if I created or wrote a software program, then I'm the owner of the copyright. If Hazel was my employee and she was an employee of my company, and she created something, then as the employer, I own it. However, if Hazel was in fact a contractor to me, an independent contractor, and she created the software program, then she would own it, and I'd have to get an assignment back to me, so I would have then owned the copyright work. So copyright is a very valuable right, and it gives the owner of the copyright exclusive rights to do certain things. So as the owner of the copyright, for instance, the software program, I can adapt it, I can reproduce it, I can license it, and it gives me a myriad of rights that I can use. So again, there's a lot of value in it. I can also assign it as well. So Hazel, do you want to talk about protection for copyright works?
So thanks, Donna. Yes, so for copyright, it's quite a long period of time that you actually have protection of a copyright work. For literary, artistic, musical work, it'll be the life of the author plus 70 years. So there's a lot of scope there to commercialise a copyright work. For other types of works, such as a TV or sound broadcast, it's 50 years from the broadcast or the published edition. So it's quite a significant period of time. Something to be careful about in relation to commercialising copyright is that, you know, you might want to keep your agreements relatively short, you know, depending on how they go, and we can stage the agreements and have milestones, etc., or break periods, and we can discuss that a little bit later. Another issue in relation to copyright is moral rights, and this is something that can often be overlooked. Moral rights are non-economic rights, so they belong to the person who created the work, regardless of who owns the copyright. So there are three types of moral rights. You've got your right of attribution, which is the right to be known as the author of the work. We've got a right of integrity of authorship, so that stops third parties from doing anything that might be considered derogatory to your work. So for instance, if you had a painting and somebody defaced the painting, then that could be considered to be derogatory. The third one is the right to stop false attribution of a work, so to have somebody who's not the author of the work named as the author. So these are quite important rights. They can't be assigned or licensed. So what you have to do when you're seeking to commercialise a copyright work is to make sure that you have the moral rights consents from the relevant author of the work. And it's really important, and particularly if you're going globally, because there are different ways, different treatment of moral rights in different countries, and moral rights isn't recognised everywhere either, of course.
No, that's right.
So it is important to look at moral rights. Where you have employees, they can give a moral rights consent quite generally. But when you're looking at contractors, again, it's a little bit different. They have to give a more specific consent in relation to moral rights. So it is something to think about before commercialising. It's the type of thing that can trip you up at a later stage. So I think that should bring us nicely into the actual forms of commercialisation.
Sure. So today we're going to talk about three main forms of commercialisation, and we're going to focus on assignments, licensing and joint ventures. And a commercialisation project can happen in a variety of ways. It could be that something's developed internally within the company. It could be that it's a startup technology company. It could be that you're licensing some IP to a licensee and they develop it for you. So whilst we're talking about those three forms, I think the thing to keep in mind is that there are other forms of ways you can commercialise. One is franchising, which we won't have time to go into today, and also research contracts. So they're the main three forms. And Hazel, do you want to start us off with assignments?
Sure. So assignment relates to transferring your right, title and interest in the IP. So you can assign all or part of the intellectual property. For instance, you might want to assign trademarks in a specific country or in relation to specific goods or services. You might also want to assign part of the IP, so you could assign 50% ownership in your IP. And if you've got a situation where you've got like a venture capitalist, for instance, coming in, they will generally look to want to own a certain amount of the IP up front, so you'll have to negotiate the actual percentage that they would own. So it's very important then in relation to that type of investment. As we mentioned earlier, generally assignments will have to be in writing, and for registered IP they need to be recorded on the relevant registers. One thing that is quite useful to do is to have a confirmatory deed of assignment. It just means that if there's anything confidential in your assignment deed, and it might have other information in there, that you can then have a very short little document which gets filed with the relevant IP office, because that's a matter of public record. So it effectively just records that your assignment has taken place without third parties knowing the details, and I think it's really quite useful to do. Did you want to talk about some of the terms that you would have in an assignment deed? Yeah,
so with an assignment deed, I suppose one of the key things that you want is you want the assignor to warrant that they own the IP. So that's probably the most important thing. You might also try and get an indemnity from them, so that if in terms of the warranties that they give you, that they indemnify you if there's a breach of those warranties. Another area that should be covered in the warranties is that there's no encumbrances on the IP. And of course nowadays you can look at the PPSR register to see if that's the case or not. But really you want to be able to know that your IP is, that the person assigning it owns it and that it is free of any charges. So Hazel, do you want to talk about assignments and license backs and why we sometimes recommend that?
Yes, absolutely. So what you can have as part of your assignment process, if you have the assignment and then you can license it back. So a lot of the time you might have this sort of scenario if you're having a group restructure and you might have an IP holding company. So you can assign the IP to the relevant holding company, and then you can have a license back scenario where it licenses back to all the various companies that use it, or also licensed to other companies. It allows you to have a revenue stream going to and from there as needed, and it also allows the IP to be deposited within the holding company, so it makes it quite safe if anything happens to the other companies that are actually operating. So that everyone can have the right to use it. And we would always recommend that there would be a license agreement in writing for even within a company, just to make sure that you have the requisite terms and conditions there if anything happens in the future.
I agree. So the next area that I thought we'd touch on is licensing agreements. And licensing agreements are a scenario where I, as a licensor, will retain the ownership, but then I license to another party. There's three main forms of licensing arrangements. You can have a non-exclusive arrangement. So, for instance, if I'm the IP owner and I want to license to a number of different licensees. So essentially, those licensees have a non-exclusive right. You can also have a sole license. So, for example, I'm the owner and I grant a sole license in Australia to Hazel to use that IP. And lastly is an exclusive license. And I think that people sometimes forget that if I was to grant an exclusive license to Hazel to use the IP, then essentially as the IP owner, I can't use that IP in the territory. Hazel's got the right to use it, the exclusive right to use it.
Yes, and it really depends on, there are certain benefits, I think, with different types of licenses. So, and it really depends on what your product is as well and what your technology is. So if you're looking at an exclusive license, I suppose the benefit for the licensor is that you can have a higher license fee. You have no expense with commercialising because somebody else is going to be doing all that. And you've also better control over how it's going to be licensed because you can negotiate all of that into your agreement. For a licensee, they can have a better return on investment. They can also negotiate, so they can actually have more power in relation to negotiation there. And they can use it potentially as security, so it is certainly very helpful. For a non-exclusive license, this, for a licensor, gives you the potential to license it to a large number of licensees. So for instance, where you have all of your software packages and you can assign it, you can license it to a large number of licensees for a very low price. So you can have a big market quite early. It's quite useful if your product is ready for market and it doesn't need any further R&D. You can have it in a standard form, so there's no need for negotiation, so it makes it all quite easy. For a licensee, it certainly can work quite easy for them. They have access to tech for quite a low price. Did you want to go through some of the terms to having a license?
Sure. The most important clause in a license agreement is the grant of the license, and there's actually a hell of a lot that you need to think about in that clause. So you need to think about, first of all, the type of IP that you're licensing and the rights being granted. And with patents, you can also identify the field of activity. And with a patent, for example, I might grant Hazel a license on a particular field, but I keep all the other fields. You also need to think about the territory. Do you just want to do Australia or a number of countries or globally? The other thing is the price. So what is going to be paid for the license? Are you going to pay a license fee or are you going to pay royalties? And also you need to think about, are you going to allow your licensee to sub-license? And on what terms are they going to be allowed to have a sub-license? So that's probably the most important term. In regard to licenses, I think that there's a few things, key points in regard to patents, because a patent, and I suppose other forms of IP, you need to make sure that your license agreement actually makes, particularly from a licensee perspective, sets out that if I'm the patent owner, that I maintain the patent, and with the patent you need to pay fees, maintenance fees for it, so that there's an obligation on the licensor to continue to maintain and also to enforce any rights in the patent. So if there's a third party that infringes the patent, you need to make sure that the license agreement covers off what's going to happen in an infringement scenario. So there are some more important terms. The other thing about patents is, and this is just a bit of a handy hint, is that under the Patents Act in Australia, Section 145 provides that at the end of the patent term, either party can give 3 months written notice to terminate a patent. So for instance, if I enter into a licensing agreement and the licensing agreement doesn't have a set term but is renewed annually, and my patent, for instance, if I'm a licensee, the patent has expired, I can actually terminate the contractual arrangements pursuant to Section 145 and give 3 months' notice. Notwithstanding that the license agreement may have different terms, it may actually say that I have to give 12 months' notice, but if the rights under the patent have expired, then I can terminate. Another area is in terms of if you're licensing intellectual property, to make sure that the agreement covers things like the marketing of the products and the distribution of the products. So they're important terms that are covered off.
Sure. Another one, when you've got licensing and you're dealing with trademarks, is to also cover off Section 26 of the Trademarks Act, which allows specific rights to an authorised user of a trademark. So usually what we would do is in our licensing agreement when you're acting for the licensor is to try to limit the applicability of Section 26, so only allow such rights to the licensee as you're actually providing under the license, because otherwise there can be other rights that they can have under the Trademarks Act.
We'd now like to talk about joint ventures, and joint ventures are where 2 or more independent companies undertake a common project. And you can have an unincorporated joint venture, which is basically where the 2 companies enter into agreement and the agreement actually sets out the contractual arrangements. Alternatively, you can actually have an incorporated joint venture. So the 2 parties actually hold shares in the JV entity. There's a lot of benefits with a JV, and that's why they are quite common. The thing is, you're bringing together 2 parties who might have expertise in different areas, so you're bringing the expertise together. It may also be that you've got 2 parties that can have R&D effort. It strengthens the financial basis for the company, so you provide financial strength. And as I said, expertise in technology. So Hazel, do you want to talk about some of the contractual considerations for JVs?
Sure. So because, as you said, you've got 2 parties who, very much arm's length, who are creating something together, developing something together, there's a lot of specific issues for joint ventures. Most importantly, the ownership of IP. And you've already discussed some issues in relation to joint ownership of IP. Where you have particularly an incorporated joint venture arrangement, which can go for a significant period of time, you're going to have improvements to the IP. So who's going to own the improvements to the IP? Will there be licenses back to the joint venture parties themselves? And then particularly, how are you going to deal with unravelling all of that at the end of the joint venture? And that's where we can have a lot of issues and where this hasn't been considered up front. And that's the time when you really should start thinking about that as to where the IP should go, how both parties can use it afterwards, or if it will just be assigned to one party. With your day-to-day management of the JV, it's important to have a management committee in place, and your agreement can provide for that, so that you can certainly work out how best to exploit the IP and how to develop it. Do you need to register it, etc. And then looking at infringement by third parties, how are you going to deal with that? And so all of this should really be set out in your JV agreement.
The other thing to think about is, even before you enter into the JV, confidentiality, because you're bringing together 2 independent parties and you need to make sure that what you've developed, that other party, even just in the early stages of discussions, keeps it confidential. So that's really important. The other thing too is actually doing some due diligence on your JV partner. Since JV arrangements actually go for a fairly long period of time, it's important to actually investigate the company and make sure that it is able to fund the R&D arrangements and so forth.
Exactly, and how they're really going to be able to commercialise it themselves. If they're promising you the sun, moon and stars and they're going to go worldwide with it, have they got the contacts to do that?
So there's lots of issues to cover off in a JV arrangement. And you need to think about profit sharing, you need to think about marketing responsibilities, you need to think about division of territories, the commercial exploitation. As you've mentioned, who's going to own the improvements in the IP that's developed during the course of the project, and also, of course, at the end, the unravelling and termination rights. So Hazel, I think now let's move on to cross-border issues, and if you want to talk about some cross-border issues.
Sure. So one of the issues with IP is that it's very much jurisdictional in nature. So a patent that is registered here will not give you any patent rights overseas. So you need to have it registered in all your relevant countries. And similarly with trademarks. So when you're dealing with cross-border issues, everything is becoming more global now in relation to commercialisation. So it's important to make sure that this is all covered off. So you need to make sure that your IP is protected in the relevant jurisdiction, at least your core jurisdictions that you're looking to. If you're manufacturing in China, have you got your trademarks registered there, even if you're not going to be selling them in China? Because you're manufacturing, and exporting, you need to have your trademarks registered there. And that's something that we have all the time, is issues in relation to registration in China. Are your moral rights ticked off in relation to other jurisdictions? Do you need to have translation of the various documents? One thing that can be quite expensive is notarization and legalization of documents in certain countries, particularly in the Middle East.
Correct. Yes.
And this is all something should be taken into account early on. And even things like recordals of assignment, and they can just prove to be a nightmare sometimes. And if you've got like a trademark in 30 different countries and you've got to record all those assignments, that's when it can all mount up the costs. So it's important to think about that in the beginning as well.
And I think that's something that you need to make clients aware of as well, because there is a lot of costs in actually protecting your IP in a number of jurisdictions. And some of the things that I just wanted to touch on when you're looking at cross-border issues is if you're dealing with companies in different jurisdictions, say Australia and Hong Kong, for example, then you're also going to probably have a bit of discussion as to what's the governing law going to be. Is it going to be New South Wales law or Hong Kong law? So that is something that needs to be covered off. The other thing that we touched on earlier was management committees. And when you've got a JV which might involve 3 or more companies, then you need to think about how you actually manage the project on an ongoing basis. And lastly, disputes. And if there is a dispute, how are you going to deal with it in the agreement? So you need to think about, are we going to deal with it internally, so it's dealt with at the CEO level, and then do we then go to mediation? And then lastly, to whether you need to have international arbitration. So for example, Singapore is an international arbitration hub. So if you're dealing with a number of companies in different jurisdictions, should we go to Singapore and arbitrate the dispute there? So there's lots and lots of issues, and more commercialisation projects involve companies in various countries. So we now want to talk about tips and tricks, and there's certain things that you need to think about right at the beginning of meeting with a client and talking about a commercialisation project. You really need to understand what their end goal is. And so, depending on what they want to do, you then need to work out, should an assignment arrangement be sufficient licensing, or do you need a JV arrangement? Another handy hint is actually putting together a term sheet. So before you launch into drafting an agreement, to actually prepare a basic term sheet setting out the main terms that the parties agree on. So you might prepare it and then send it to the other side lawyers to have a look at. And once you've agreed the basic terms, then you can start drafting the agreement. So Hazel, there's some other things that you can give handy hints on?
Yeah, sure. So due diligence, as we touched on earlier, is obviously key if you're going to be doing any sort of commercialisation and you're involving a third party. And this could be any type of a third party, be it a distributor, a JV partner, any third party at all. You need to properly make sure, if you're going to be the licensee, for instance, that they actually own the IP that they say they own. And if you're the licensor, or if you're getting someone to distribute a product or technology for you, that they actually do have the wherewithal to do that. And particularly if you're giving them exclusive license, and you're depending on the revenue stream, then they need to be able to actually, have the content, be able to sell it in all the various countries that they say they can. Ownership of pre-existing and new IP is really, really key, and that's where people get tied up quite a lot. So just making sure that you can actually define who owns what before the agreement kicks off, and then what happens in relation to project IP as things are developed throughout the course of the relationship.
Yeah. The other thing too is that right from the beginning we talked about the phases of a commercialisation project. So when you're starting off drafting your agreement, to think about all the phases that you're going to have to go through, from R&D to prototype to manufacturing to distribution and marketing, and really making sure that your agreement covers all those aspects right through to termination, the parties going their separate ways. So it is a long-term project, and it really, you need to take all of that into consideration.
Absolutely. And one thing when you are commercialising, and as you might have more and more licensees, for instance, or different types of technology, one important little tip is to have an IP register in place.
Yes. Good idea.
So you can then have your contracts on your register, have your key dates, your milestone dates, your royalty payments, any increases or changes in fees, any break clauses or options. So for instance, if you're a licensee and you got an option to buy out the IP, that's all marked, and that you would have that diarised for the relevant people within the company.
Yeah, and even thinking about, because your IP has different periods of protection, so your trademarks, the 10 years, to make sure your diary actually covers all those renewal dates, so, and similarly with the patents, the 20-year period, and when you need to pay maintenance fees and so forth. So absolutely, it's a great idea.
Yes.
So thank you very much, and we hope you enjoyed the seminar today.
Thank you.